This video will provide an introduction to Bill C-92, an act respecting First Nations, Inuit and Metis children, youth, and families. Over the course of this video, we will talk about what Bill C-92 is, some of the background issues that led to its implementation, the minimum standards that are set out in the Act. As well, we will briefly touch on some of the concerns and criticisms of the Act. So, let's get into what exactly is Bill C-92. On February 28, 2019, the Government of Canada introduced Bill C-92. A bill is proposed legislation which does not become law until it is passed by the legislator. On June 21, 2019, Bill C-92, an act respecting First Nations, Inuit and Metis children, youth, and families, was passed by the legislator and became official law. On January 1, 2020, its provisions came into force, meaning that the laws set out in this act now apply throughout Canada. This law did two main things. It recognized that Indigenous peoples have the inherent right to jurisdiction over their own child and family services. It also set out national minimum standards for providing child and family services relating to Indigenous children and families. More on this later. So, why is this important? Let's take a step back and look at the background issues that led to the implementation of this act. The Indigenous child welfare system has long been plagued with underfunding and discriminatory practices, which has led to the overrepresentation of Indigenous children in foster care. According to Census 2016, Indigenous children represent 52.2% of children in foster care in private homes in Canada, despite accounting for only 7.7% of the overall population of children under 14. There are more Indigenous children in care right now than there were during residential schools. For decades, the Canadian government has enforced policies that have led to Indigenous children being apprehended and separated from their families. For example, Indigenous children were removed, often forcibly, from their families during the Indian residential schools era, from the late 1800s until the last school closed in 1996. As well, from the 1960s to the 1980s, Indigenous children were adopted into or fostered by non-Indigenous families during what has become known as the 60s scoop. In many cases, this was done without the consent of their families. There has long been a need for a child and family services system that recognizes the important role of Indigenous culture and community in the lives of Indigenous children, and that allows Indigenous communities to assume jurisdiction over the care of their own children in accordance with their own laws and traditions. Before the implementation of this legislation, the jurisdictional framework that was in place led to ambiguity over who was responsible for services for First Nations on reserve, and delayed and impeded access to these services. Jurisdictional disputes between different levels of government over who was financially responsible for the provision of services has had a significant effect on service delivery and the well-being of Indigenous children. The Truth and Reconciliation Commission's calls to action, as well as the United Nations Declaration on the Rights of Indigenous Peoples, were both driving forces that led to the implementation of Bill C-92. The Truth and Reconciliation Commission has stated that Canada's child welfare system has simply continued the assimilation that the residential school system started. They issued 5 calls to action aimed to fix this broken system. This included, in particular, Call to Action number 4, which called upon the federal government to enact Indigenous child welfare legislation that establishes national standards for Indigenous child apprehension and custody cases. This is exactly what Bill C-92 did. The United Nations Declaration on the Rights of Indigenous Peoples also had a great influence on Bill C-92. Not only does the federal government recognize UNDRIP in the preamble of Bill C-92, but they actually stated that the legislation itself is an implementation of UNDRIP in Section 8C of the Act. Now that we have a bit of an idea of some of the background issues that led to the implementation of this Act, Let's take a look at some of the minimum standards that are set out in the Act. Since the implementation of the Act, federal minimum standards apply to the provision of all child and family services in relation to an Indigenous child. These minimum standards prevail over provincial child and family services laws where there is a conflict to the extent of the conflict. Section 10 of the Act sets out that the best interests of the child is the primary consideration in decisions or actions regarding the provision of child and family services. According to this provision, primary consideration is to be given to the importance of the child's relationship with their family and Indigenous group, and preserving their cultural connections. This section also lists factors to be considered in making this decision. Section 11 sets out that in carrying out their duties, child and family services must take into account the child's needs, culture, allow the child to know his or her family origins, and promote substantive equality. Section 12 and 13 of the Act allow for the child's parents and community to be more involved in the child and family services process. Section 12 requires that service providers must give notice of any significant measure to the child's parents, care provider, and Indigenous governing body. Section 13 sets out that the child's parents, care provider, and Indigenous governing body have a right to participate in any civil proceedings regarding the provision of child and family services. Section 14 places an emphasis on preventative and prenatal care and states that these are to be given priority over other services. This is important as it sets out that preventative care to support the child's family is to be given priority over other measures such as removing the child from their family and culture. Section 15 provides that a child must not be apprehended solely on the basis of socioeconomic conditions, and that reasonable efforts must be made to have a child continue to reside with their parents and family. This section could be important in ensuring that decisions regarding Indigenous children are not made based on discriminatory assumptions. Section 16 sets out the order of priority that is to be followed when placing the Indigenous child in care, unless this would be contrary to the best interests of the child. You can see that the order of priority prefers the child to be placed with someone in their own family or culture before being placed elsewhere. Section 17 provides that if the child is not placed with their family, the child's attachment and emotional ties to each member of their family should be promoted. While Bill C-92 was a great step forward in terms of self-government rights for Indigenous peoples and improving the Indigenous child welfare system, there are some criticisms of the Act. The main criticism is that the Act does not provide for any guaranteed funding. As mentioned earlier, Canada does not have a strong track record when it comes to funding Indigenous child and family services. Without guaranteed funding, critics say that the recognition of Indigenous jurisdiction is simply an empty promise. It is also worth noting that Quebec challenged the constitutionality of this legislation, but it was mostly upheld at the Quebec Court of Appeal. However, this issue is still before the courts. Let's do a quick recap of what we covered. We learned that Bill C-92 now applies throughout Canada. This act affirmed the rights of Indigenous peoples to exercise jurisdiction over child and family services, and it established national standards to apply to the provision of child and family services in relation to Indigenous children. We looked at some of the reasons this act was needed, such as the perpetual underfunding of Indigenous child and family services, jurisdictional disputes, the overrepresentation of Indigenous children in care, the dark history of residential schools, and the 60s scoop. We also looked at some of the driving forces that led to its implementation, such as the Truth and Reconciliation Commission and the United Nations Declaration on the Rights of Indigenous Peoples. We looked at some of the important principles and sections set out in the Act relating to the best interests of the child, cultural continuity, and substantive equality. We also learned that the main criticism of the Act is that it does not provide for any guaranteed funding, and that Quebec has launched a challenge to the constitutionality of the Act.